A person at the jail, please state your name for the record.
Nadia Yates.
This is case number 26-1030 SM, the people of the state of Michigan versus Nadia Celine Yates. Ms. Yates, did you have the opportunity to meet with somebody from the defender's office today?
Yeah.
And looks like you met with somebody from Community Corrections and gave them some contact information. Was that information accurate?
Yes.
I have a complaint that alleges that on or about March 28th, 2026, in the city of Cadillac for Wexford County, it is alleged in count number 1 that you committed the offense of child abuse 4th degree.
What?
By did knowingly or intentionally commit the following act or acts that under the circumstances posed an unreasonable risk of harm or physical injury to a child by grabbing and holding onto her while struggling with police officers who were trying to detain and then arrest.
No,
That is
she
a
jumped off.
Hold on. I don't want you to say anything about the case yet, all right? So I've got a process I have to go through, so let me do that first. That is a misdemeanor punishable by up to 1 year in jail or probation for up to 5 years. I'm not asking if you agree with the charges, but do you understand that that is what you have been charged with and what the potential penalty is?
No, I thought it was an R. No.
No, I understand that, but based on what I just read to you, do you understand that you've been charged with a child abuse 4th degree and that the penalty is up to 1 year in jail and probation for 5 years? Do you understand that?
Yeah.
Did you read and sign an advice of rights form at the jail talking about your rights to an attorney and your rights to a trial?
Yeah.
Did you understand those rights?
Yeah.
Are you sure you understood them?
Yeah.
Okay. You do have the right to be represented by an attorney at all phases throughout this process, and if you could not afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Get an attorney.
All right, the court will make a referral to the public defender's office for the appointment of an attorney. We'll enter a not guilty plea and we'll set the matter for a pretrial. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Also, I show in 21, there is an allow another to operate in violation of the motor vehicle code, a driving while license suspended, a larceny less than 200, another driving while license suspended. In 22, there was an operating without security and driving while license suspended, along with that same year, a failed to report an accident, and in another case, no license. In 21, there was also a retail fraud third. The praxis scored her at a risk level 5. However, I believe there's a mistake. I understand she was booked on a felony, but not charged on a felony. So I think that I think that reduces her from a level 6 to a 5. Any comment regarding bond, Mr. Harrison?
I'm astonished that she's a level 5 based on her overall relatively minor criminal history. And my understanding of the events in question here was that there was essentially someone who believed she had left her children alone in a car for too long a time period in the parking lot of Loom. I believe that she's a good candidate for a PR. She has family in the area. She's going to be staying with her grandmother. As a matter of fact, the address she gave to Community Corrections is that of her grandmother. She's not going anywhere. She hasn't gone anywhere. She lived in this area basically her entire life. She does have young children. They're temporarily placed with her mother. The
No,
other
grandma.
elephant grandma. The other, I'm sorry,
She's
the other
82.
elephant, I know, the elephant in the room is that Yvonne Nelson is 82 years old, can only do so much in terms of being with the kids. She does have a fairly recent failure to appear on something. We couldn't tell what it was. And she's involved in a contempt citation in circuit court that was dealt with earlier this morning. I think all things considered, she's a good candidate for PR. She lacks the resources to post any monetary bond. And I just don't believe it to be necessary in this case, despite the charges. Thank you.
What was the contempt?
She is alleged to have assisted someone in obtaining clean pee to pass a drug test that he otherwise would have failed.
And when you say it was dealt with this morning, was that dealt in its entirety or just arraigned on the contempt? Or?
It was just an arraignment in
I got
PR.
time served.
Oh, so it was dealt with. I'm sorry.
Yeah.
I wasn't there.
Okay. All right. And was her fail to appear for financial review hearing? Do you know?
Was that it?
It sounds familiar, but I don't know. While we're looking that up, Ms. Lawrence, any comment regarding bond?
Thank you, Your Honor. Mr. Harrison is correct. This did start. Officers were dispatched to Loom for two very small unattended children in a vehicle while the defendant was buying marijuana in the store. She was being detained for the warrant from circuit court, in which was alleged in the complaint occurred. Given that, I would ask for a no unsupervised contact with anyone under the age of 16 provision. As for other bond conditions, I will leave that up to the discretion of the court.
So I know what the complaint says, but can you fill me in a little bit more as to the allegations?
Yes, essentially the officer told that she was being detained and placed under arrest for active warrant. At that time, the defendant opened the door of the vehicle and grabbed one of her small children.
I didn't grab the child.
Hold on, Ms. Yates, you had the right to remain silent, so I highly suggest you invoke that right. Go ahead.
At that point in time, the defendant refused to let go of the child as the officer was trying to place her under arrest.
That is bullshit. It's not even true.
Was there a struggle?
Yes, they did end up on the ground at one point. The officer did wait for more officers to show up.
Is there any type of CPS case open? Do we know?
I'm unsure of that.
All right. Did she have a warrant for us or no?
I don't
Was it just a
know,
circuit?
but I'm looking through, she's got several cases here, I'm not finding any place yet.
All right, sounds like it's just a circuit court case. All right, Ms. Yates, as a condition of your bond, you are to appear as ordered to keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm also going to order that you not consume any illegal controlled substances, and I'm also ordering no recreational marijuana, and you'll be subject to random testing. I believe that's appropriate given the location as to where this is alleged to have happened at, which does raise questions about whether the defendant may have been under the influence of some sort of controlled substance. For the time being, I am going to order that there be no unsupervised contact with anyone under the age of 16. Mr. Harrison, obviously your office knows how to file a motion if you feel as though that's appropriate. Also ordering that the defendant enroll in community corrections services. I will release the defendant PR, Ms. Yates, which is your promise to come back to court. A question I do have, Ms. Yates, I know you gave a mailing address on Manning Street. Is that where you're actually staying or is that just where you receive mail?
I will be staying there.
All right. At some point today, you're going to be released from the jail. Before you're released, you'll have your next court date. Make sure you keep track of that. Also, once you're released, you'll need to come over here to community corrections at the courthouse and get signed up for your testing requirements and community correction services. And just a reminder that if you are found to be in violation of your bond conditions, you could be arrested without a warrant, brought back to jail, and have your bond revoked. You understand that?
Okay.
All right. Thank you. Next to Raymond, jail.
Your Honor, I believe that's it.
What happened to this Karutny fella?
He bonded out.
Oh, he bonded out? Okay. So is Mr. Keeley bonded out as well?
He was never.
I'm sorry, what was
Oh,
the name?
I'm being told he was never kept. All right. Thank you, jail. Welcome to
Thank
Monday.
you, Your Honor.
Thank you.
I have some answers, Judge. Maybe not the right ones you need to.
FD. Ms. Vedler, are you able to see and hear me?
I can hear you. I can see you a little bit.
All right. And Ms. Henry appears on behalf of the Grand Traverse Prosecutor's Office, acting as special prosecutor in this case. Ms. Henry, are you able to see and hear me?
Yes, I can.
All right. Well, Ms. Vedler, you are here on an alleged probation violation. It's alleged that you were in possession of alcohol in violation of your probation order on March 20th, 2026. That is a technical violation, or alleged to have been a technical. And also that you have a non-technical violation by having new criminal behavior of operating while intoxicated, driving while license suspended, as reported by the Missaukee County Sheriff's Office on March 29th, 2026. If you are found to be in violation of your probation, you could be sentenced to what you could have been sentenced to under the plea agreement in this case of operating while intoxicated second, so up to a year in jail. Do you understand that?
I'm confused about the 20th, Your Honor, but
Yeah, I'm sorry, I couldn't hear you. You're confused about what?
I said, what was the March 20th?
March 20th, it's alleged that you possessed alcohol. And then on March 29th, it's alleged that you had new criminal behavior of operating while intoxicated and operating while your license was suspended, as reported by the Missaukee Sheriff's Office. Do you at least understand that based on the information the probation office has, that that's what they have charged you with as a violation?
I do understand that I'm being charged with that. I'm still confused.
Okay.
But,
Now, do you also understand that if you are found to be in violation of your probation, you could be sentenced up to a year in jail? Do you understand that?
I do, Your Honor. I hope that that doesn't happen. I made a mistake.
All right, Ms. Vedler, you do have the right to have an attorney at all phases throughout this process. And if you cannot afford one, one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. You also have the right to have a contested hearing in this matter, in which the prosecutor would have to prove to the court that you did in fact violate the terms of your probation, or you could admit responsibility to those violations, or plead guilty, in other words. So my first question to you is, today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Currently, I guess I'm going to try to request the court to appoint me an attorney, please.
All right, the court will go ahead and will make the referral to the public defender's office for the appointment of an attorney. We'll enter a not guilty plea, and we'll set the matter for a contested hearing. That brings us to bond. Mr. Harrison, do you have any input on bond?
I do, Your Honor. Obviously, it's my understanding that the charge of Missaukee is an OWI third. Is that accurate?
I haven't seen the charge, but I would assume so. She was a third in this case, pled to a second.
That's my understanding as well. So she is still, in fact, on circuit court probation.
She's on district court probation.
Oh, I had no idea.
Because she pled to the second. Here.
You signed it too. I'm sorry, Your Honor. I'm looking right at the judgment. I do not accept to say that I would have you set a bond, because we don't know how that's going to play out in Missaukee. We'd at least like to have something to shoot at here.
All right. Ms. Henry, on behalf of the people, any comment regarding bond?
Yeah, and I think at this point, I would ask for a high cash bond or no bond at all, given that it's been just a couple months since sentencing. If you recall her prior, so I guess her true second, she also within a couple months did not do well and was testing positive, and that probation was revoked. So I guess at this point, I don't know what else we can do to protect the public safety.
Thank you. Ms. Vedler, have you been arraigned on the new charges in Missaukee County yet?
I was, Your Honor.
What was your bond set there?
It's 25,000.
25?
Yes.
Well, this is not the defendant's first drunk driving. As Ms. Henry stated, there had been a short period of time
I'm
after her
sorry.
last drunk, between her last drunk driving and this one. Ms. Vedler, are you there? The defendant, while she did perform well on bond, was just sentenced on this case back in February, I believe it was. And the underlying blood draw at the time of the offense she's on probation for was a .203. So I do believe a remand is appropriate. I believe that's appropriate for public safety. I am going to remand the defendant to the custody of the jail until we have the contested hearing. Anything else for the record, Ms. Henry?
No, Your Honor. I guess if there is going to be a hearing, just have the attorney or probation or someone reach out to us if they want us to be there.
For sure.
All right, thank you. Mr. Harrison, anything else?
I have nothing further, Your Honor.
All right, thank you. Thank you, Missaukee.
Thank you.